In fact, in this entire 22-year-old triple murder case, NewsX now has access to the Supreme Court judgment copy that led to the acquittal of the Odisha man Arjun Jani, who spent over 2 decades in prison. The apex court, while setting aside the conviction, observed that the prosecution failed to establish the case beyond reasonable doubt and that the evidence presented was not reliable enough to sustain the conviction. Let me in fact go across to my colleague Yash Ahuja, who has the judgment copy, and he will in fact get you those minute details as to what has been observed by the Supreme Court. Yash, can you take us through the details of this court order, please?
Yes, Shivani, NewsX has now exclusively accessed the Supreme Court order of, acquitting Arjun Jani, the man who spent 22 years behind the bars and wrongfully accused of doing a crime. Now, point number 7 of the copy reads that the learned counsel appealing for state referred to Annexure P4 in answer to a query regarding the remission policy. It is seen from Annexure P4 that the application of the appellant for remission was rejected 6 times. The last of which was on 19/9/2025, that is 19th September 2025. The order noticed that after 22 years of actual imprisonment, he is 45 years of age, and with remission, he would have undergone 25 years of incarceration. It is specifically recorded that it is submitted here that both the policy for the year 2000 and the current policy are beneficial to the petitioner with regard to his premature release. However, the Deputy IG of Prison lamented that as per Clause 6.4 of Law Department Resolution, as well as Clause 8.4 of the current policy, the case of petitioner will be reconsidered by the State Sentencing Review Board only after expiry of 1 year from the date of last consideration. It further reads that be that as it may, we looked into the merits of the matter, and from testimonies we see a pall of incredulity. Before we examine the evidence, we have to notice that the scene of occurrence, discernible from the deposition, was a locality with cluttered houses, no electricity, a factory nearby which operates with deafening sound and inhabited by people from the marginalized sector. The deceased were numbered 3 and named Kamala, Sonbari and Ratnai, residing in the place in separate houses. The witness too were neighboring residents. PW3, the eyewitness spoke of having seen the accused striking the head of Ratni, residing in the locality, and tried to intercede, but when threatened by the accused, fled in fear to the house of PW4. There is no clarity as to whether she informed the gruesome incident she witnessed immediately to PW4 or not. Next day morning, PW3, on returning to her house, found some villagers gathered at the alleged scene of crime. PW7 says that they went to a tea shop in the morning nearby, recited the incident together with others, came back to the crime scene. She then found the bodies of Kamala and Sonbari lying at the scene of the occurrence for the first time, and was then made aware of 2 other deaths having occurred on the same night. All of them were women. PW3, in cross-examination, admitted that her husband was in the house on that night, and later she said that she had gone out for dinner. The copy further reads that the prosecution went to trial with eyewitness testimony and the corroboration by the way of race gap, as coming out from PWs 1 to 4 and 7, who have different versions as to how they came to hear the version of PW3 about the incident. In cross-examination, it was deposed that she witnessed the assault from within her house, peeping through a gap in the door at 1 o'clock in the night. The IO denied the testimony of PW3 that she spoke of the occurrence to PW2, having been stated to him at the time of investigation. Said the testimony of PW4 that PW2 was trembling out of fear and she slept in her house also was not recorded in her statement under Section 161 of the Code of Criminal Procedure 1973. The further copy read that there was an earlier incident deposed to by PW3, corroborated by PWs 2, 4, 7 and 9 of the accused, having roamed the streets screaming that he wanted to quote-unquote kill someone, with no name disclosed. PW3 also stated that the accused walked into her house, took a tumbler, and later went to Kamala's house, one of the deceased, with liquor. More shocking is the statement of PW3 that from her house to go to PW4's house, she has to pass Kamala's house, in front of which the two other bodies were seen. This has to be juxtaposed with the fact that PW3 witnessed the murder of only Ratnai and not the others, and while she was fleeing at that night, she did not see the other dead bodies lying on her way to PW4's house. It further reads that relevant is also the fact that IO PW13, who also carried out the inquest, has not spoken of the scene of occurrence nor prepared a sketch, especially when 3 bodies of murdered victims were recovered. It is pertinent that PW13 does not have any explanation as to how he reached the accused and arrested him, but speaks of a confession having been made by the accused after his arrest, which definitely cannot be relied upon, and is also inadmissible under Section 25 of the Indian Evidence Act. Very significantly, PW8, one of the witnesses of the recovery under Section 27, speaks of the police having beat the accused to extract the confession. So in the end it reads that the recovery of MO1 and MO3, stones and brick, from the accused as spoken of by the IO was specifically rejected by the trial court. Rightly so, since there was nothing found in the stones recovered connecting those to the murder. This is the most important part. No blood stains were visibly seen as deposed by the IO, nor were any detected on any chemical examination at the Forensic Science Laboratory, which report, though produced no positive result, was spoken of by the IO. Again, while the IO spoke of the recovery of MO1 and MO3 from the bushes near the scene of crime as pointed out by the accused, PW1, the first informant, the eyewitness, and the Mazhar witness of the recovery consistently said that MO1 to MO3 were lying near the bodies in plain view and with no blood stains. So yes, we have this copy which Supreme Court very clearly points out that there was not much evidence there against the accused. The appeal stands allowed with the above description, and pending applications shall also stand disposed of. So yes, that's what the Supreme Court has said, and we have obviously exclusively accessed the Supreme Court judgment copy. Back